But at its core, this case is about whether Washington law protects a worker who develops a disease because of her occupation. It's worth noting that this is an appeal under the Industrial Insurance Act, and as so, it is a legal error case, not a credibility dispute. The Industrial Insurance Act is remedial. It is to be liberally construed in favor of the injured worker. Accordingly, where the evidence permits, doubts should be resolved in favor of coverage. As you know, I'm here on behalf of Ms. Terry Glassett Hanson. Ms. Glassett Hanson was a longtime WestRock employee who performed hard, repetitive work at a cardboard manufacturing plant for many years. The board heard substantial evidence that her work required repetitive lifting of cardboard bundles, sometimes weighing up to 110 pounds, along with repeated bending, stooping, prolonged standing on concrete, 12-hour shifts 6 days a week, and physically demanding pallet work. And these demands only intensified during COVID when Ms. Glassett Hanson was an essential worker and production demands increased. By March 2021, her low back pain had become so severe that she could no longer report to work. She could not get herself out of bed or walk normally. This was not a simple strain or ordinary aging. It was the result of years of physically demanding factory work performed day after day at WestRock. There's no evidence that Ms. Glassett Hanson had any prior history of back problems before her work at WestRock. The record establishes that she entered employment with WestRock healthy. She passed her pre-employment physical with WestRock and developed these new symptoms only years after repetitive, physically demanding labor. And her attending provider agreed. Ms. Glassett Hanson applied for benefits through the Department of Labor and Industries and was unfortunately denied. The denial was affirmed by the board, and this was an error, and that is why we are here today. So the question before the court today is straightforward. Whether Ms. Glassett Hanson's L5-S1 disc herniation with left S1 nerve root impingement arose naturally and proximately from the distinctive conditions of her employment at WestRock. The evidence demonstrates that it did, and we ask the court today to reverse the decision of the board and allow claim SM 66935. And while board decisions are afforded the presumption of correctness, the presumption is rebuttable. Here, the presumption is overcome because the board's decision rests on a mistaken view of occupational disease law and on expert opinions founded upon an inaccurate description of the actual workplace exposure itself. And in short, there are three reasons why the board's decision cannot stand. First, the legal standard favors coverage where employment causes or aggravates a disabling condition. Second, every element of the occupational disease causation is established by the evidence. And third, the employer's contrary evidence lacks foundation because it rests on that outdated understanding of the job analysis actually performed. So let's get into it. The court's analysis should begin with the Industrial Insurance Act itself. The act is remedial in nature, and it must be liberally construed in favor of the injured worker, with doubts resolved in favor of coverage. Under RCW 51.08.140, an occupational disease is one that arises naturally and proximately out of employment. As the Supreme Court explained in Dennis, a disease arises naturally when there's a logical relationship between the worker's condition and employment, and proximately when it is more probable than not related to employment. Critically, the worker need not prove employment was the sole cause. Washington law is very clear. The worker is to be taken as she is. And under RUSE, benefits are available where employment either causes a disease or aggravates a pre-existing condition into disability. So even if degeneration existed, the question is whether the employment caused disability, aggravated that condition, or contributed to the disabling pathology. The existence of degeneration is not a defense if the work transformed an asymptomatic condition into a disabling one. This is very important as the board's analysis appears to conflate the existence of degeneration with the absence of occupational causation, and those are not the same inquiry. Even accepting that some testimony differed about the precise frequency or weight of lifting, the board still applied the wrong framework. It treated degeneration as inconsistent with occupational causation, and under RUSE, that is not the law. The question is whether work caused, aggravated, accelerated, or contributed to the disabling condition. Here, Ms. Glassett Hanson experienced distinctive workplace conditions capable of causing or contributing to an occupational disease. Again, for years, she worked 12-hour shifts, 6 days a week. She repeatedly handled cardboard bundles weighing between 30 and 50 pounds and sometimes more than 100 pounds. She stood on concrete, repeatedly bent, stooped, lifted, and stacked throughout her shifts. And these demands increased. During the COVID pandemic, production demands grew substantially, staffing shortages became common, and Ms. Glassett Hanson frequently performed additional pallet work requiring repetitive and forceful handling of heavy materials. There's nothing unusual about concluding that years of this type of heavy labor can affect the lumbar spine. In fact, the evidence establishes precisely that type of repetitive workplace exposure contemplated by Washington's occupational disease statute. This was not ordinary life activity. These were distinctive industrial exposures, 12-hour shifts, 6 days a week that were admittedly mandatory, repetitive lifting, prolonged standing on concrete, repeated bending and stooping, with demands only increasing with COVID. The timeline is compelling. Before West Rock, no back pain. Then years of repetitive work at West Rock. Then gradually worsening symptoms. Then by March 2021, symptoms becoming so severe that she can no longer get out of bed or walk normally. Then medical treatment following. This timeline establishes a continuous progression from workplace exposure to disabling condition. And the employer in their brief points to this gradual onset, but gradual onset is not exactly what occupational disease claims often look like. Strike that. The gradual onset is exactly what occupational disease claims often look like. The disease does not have to appear suddenly. A progressive worsening over years of exposure is consistent with Washington occupational disease law. And objective medical evidence supports the same conclusion. The MRI showed lumbar pathology, and Dr. Chan diagnosed a lumbar disc herniation with radiculopathy. Conservative treatment failed, and ultimately surgery was required for the the L5-S1 disc herniation that was impinging on the S1 nerve root. So not only could a reasonable person infer a causal connection exists, importantly, Dr. Chan directly attributed the condition to the repetitive lifting, the bending, the stooping, the squatting, and the heavy physical demands of her work. This is so important because under Hamilton, the treating physician's opinion is entitled to special consideration. And Dr. Chan, as her attending provider, was uniquely situated to evaluate causation because he treated Ms. Glassett Hanson, followed her condition over time, reviewed the imaging, and ultimately managed her treatment that led to surgery. Now, the employer argues that Dr. Chan relied on an inaccurate work history, but the record does not support that characterization. Dr. Chan understood the key facts: repetitive lifting, bending, stooping, and years of physically demanding factory work. These are the exposures that are supported by the record, and at most, the parties dispute the exact frequency and the weight involved. So thus, Dr. Chan's testimony satisfies the more probable than not standard, and this is not a situation where causation is speculative. In sum, both the lay testimony and the medical testimony in the CABR support the conclusion that her condition arose naturally and proximately from employment. But before we completely move on from Dr. Chan's testimony, it's very important to reiterate that Washington law recognizes that special consideration is to be afforded to the attending physician's opinion. And this principle exists for a reason, because Dr. Chan treated the claimant, followed her symptoms over time, reviewed diagnostic findings, observed the failure of conservative care, and managed treatment through surgery. His opinion is not based on a paper review or a one-time examination. It was based on treatment and long-term observation. This is in contrast to West Rock's physicians who either conducted record reviews or one-time evaluations. Their understanding of the job depended heavily upon an outdated job analysis from 2009, rather than an actual job duties described by the worker. So the question becomes, how reliable are defense opinions about causation if they're based on a job that the claimant was not actually performing? The answer is not very, because causation in an occupational disease case depends on exposure, and exposure depends on the actual physical demands of the job. And the only witness who personally experienced every shift, every production increase, every staffing shortage, and every physical demand over the relevant years was Ms. Glassett Hanson herself. By contrast, the employer's vocational counselor, Ms. Bush, relied heavily on that job analysis created in 2009. She acknowledged it had never been updated, and she did not fully account for the evolving job duties and the increased workplace demands during the COVID pandemic. The medical experts retained by the employer similarly relied on the outdated analysis and failed to account for how the job actually evolved over the years. And Dr. Zoltani, one of the employer's medical experts, could not even recall whether he reviewed or relied upon the job analysis at all when forming his job opinion. So when the court compares the evidence, on one side, there is a worker who performed the job with years of symptom progression, objective diagnostic findings, surgery, and the opinion of her treating provider who is to be given special consideration. And on the other side are experts whose opinions were derived from a job description created more than a decade before the relevant events and before the increased demands described in this record. That evidence simply does not overcome the plaintiff's showing, especially when the legislature has instructed courts to construe the act liberally and resolve all doubts in favor of coverage. In closing, Your Honor, this is exactly the type of claim that the Industrial Insurance Act was designed to protect. Ultimately, this case comes down to whether years of repetitive and physically demanding factory labor contributed to the disabling lumbar condition and forced Ms. Glassett Hanson from the workforce. The objective medical evidence confirms that condition, and the timeline confirms the progression. The treating physician confirmed causation. The employer's contrary opinions depend on a significantly different description of the work actually performed. So under Dennis, Roos, and Hamilton, and the liberal construction mandate of the Industrial Insurance Act, the evidence establishes that Ms. Glassett Hanson's occupational disease arose naturally and proximately from the distinctive conditions of her employment. To find otherwise would be legal error. Accordingly, we respectfully ask that the court reverse the board's decision, reverse the department's rejection of claim SM 66935, and direct the claim to be allowed. Thank you.
Thank you. Apologize for the cough there. I'm fighting this for a couple of days. All right, Counsel, response.
Thank you, Judge. And just so I know, you can hear me okay?
I can hear you great. Thank you.
Okay, thank you. On behalf of West Rock Services, my name is Brett Schopper. I did have the opportunity to present this case, not only at the department level, but at the board. And we are asking that Your Honor affirm the presumed correct board decision after thorough review of the evidence. And you'll see why denying this occupational disease claim was appropriate in not only review of the claimant's testimony herself, but in comparing what counsel had characterized as a crucial timeline here with respect to the alleged onset of her symptoms. Before we get into some of the evidence that I'd like you to key in on as you go through the record, I want to correct a couple of things in not only counsel's briefing, but also in argument offered to the court just now. We've heard multiple occasions that Title 51 indicates that all doubts are to be resolved in the claimant's favor. And while that is a principle, Judge, if you actually look at the case and appellate decisions with respect to that standard, it has to do with statutory interpretation of Title 51.
Let me stop you for 1 second. You're breaking up just a little bit on your audio. I'm not sure if that's your microphone or because it kind of like cuts out and back and forth.
Picking up with respect to the liberal construing in favor of claimant, that has to do with statutory interpretation. So here you're weighing a preponderance of medical opinion evidence, reliable and credible opinion evidence to establish whether there is a compensable occupational disease. That liberal construction rule does not apply in this particular situation. It's not an appropriate argument. It's not an appropriate argument, Judge, to be making in this particular case. And you will see in the decision even cited by counsel in the Lyons decision, if you go through it, it was actually involving a franchise and a franchisee in establishing whether or not a worker was in fact met the definition of that to provide benefits. So it's not a situation where we can say, well, if there's doubts, then the doubt goes in favor of the worker in each and every instance. That's not an appropriate argument in this case as a basis to rule in claimant's favor. Putting that aside, we also heard argument that Dr. Chan, their sole testifying expert, was a treating provider who was entitled to special consideration. First off, special consideration does not require you to provide more weight to that particular individual. It's just, as you know from the jury instruction, I'm sure, and the McManus decision, it just requires that you take that into special consideration, their opinions when evaluating the evidence. And in this instance, the special consideration rules wouldn't apply at all because Dr. Chan, by his own admission, you'll see in the records, he didn't even know if he was treating or primary care provider for this particular worker. Counsel had represented to you that Dr. Chan has had an opportunity to assess and evaluate the claimant over a prolonged period of time. And as a result of that, that has rendered his opinions to be more reliable and credible. And you'll actually see that Dr. Chan did not become involved until August of 2021. He actually had 2 phone visits, August 4, and I believe the next was August 21 of 2021. And then he had only 1 face-to-face visit. So he had only 1 face-to-face visit, only 1 opportunity to evaluate the patient. And the examination of the patient here is not in dispute. Everyone is in agreement that she had an insidious onset of a disc herniation that occurred while outside of work. So to claim that Dr. Chan is entitled to special consideration because he had a prolonged treatment relationship and an ability to monitor and evaluate the patient over a long period of time is inaccurate. She had a follow-up visit scheduled with Dr. Chan in October of 2021 and didn't follow up with him. We next have Dr. Weinstein, who was the attending physician who operated and performed the surgery. Now, that would be an individual who potentially could have special consideration, but you didn't get the luxury of hearing any of his testimony because the only individual to testify at the request of claimant was Dr. Chan, who only saw her on one occasion face-to-face, and he did have, as we'll see, an inaccurate understanding of the facts per his own admission. So putting those 2 things aside, the fact that this act or the evidence that you're assessing can't just be resolved in favor of claimant because there's conflicting evidence. That's an inappropriate standard. And putting aside the special consideration for an individual who simply just facilitated claimant filing a claim at her request. We then move to the actual evidence in this case, Judge. And as counsel had said, I believe in her argument, that the timeline here is important. There's been a representation that there has been a progression of lumbar symptoms and problems that have gotten worse over the course of her employment with Westrock, working in a variety of different positions. First and foremost, she had only worked there for 5 years, doing a number of different types of positions. And you'll see from the medical records that there were no complaints and problems lodged whatsoever during her time that she was employed. And when we turn to the actual timeline as to the onset of her condition, and as incorrectly stated in her testimony before the board, Ms. Glassett Hanson's testimony and in briefing, there was a representation that in March of 2021, Ms. Glassett Hanson's low back pain became so exacerbated that she could no longer report to work. She could no longer even get herself up out of bed nor walk. That was the representation, that it was somehow her lumbar condition that took her out of work. But you'll come to see that, in fact, her father unfortunately committed suicide on March 10 of 2021. She took leave directly when that happened. So she was out on leave when that happened. It wasn't a consequence of any lumbar condition, any worsening of a condition. And then you'll see that she first initiated treatment for a lumbar complaint and problem while still out of work. First visit was with Dr. He, and that was April 20th, 2021. And the history that she reported to Dr. He, and again, these are in the contemporaneous medical records, they're in as substantive evidence, an individual who is reporting a history of onset of condition to a treating provider for the purposes of obtaining treatment. And for that very reason, there is more credibility as opposed to an individual who later changes her story and is attempting to get benefits for a particular condition. And you'll see that she reported to Dr. He that 3 weeks prior to that visit, she had an onset of low back pain while painting her bathroom with symptoms that extended down into her left lower extremity. That was the history that was reported. So we have an individual who goes out in March 10 of 2021. She doesn't treat till April 20th, and she reports at the end of March is when she had an acute onset of low back pain while painting with symptoms down into her leg. She treats again after that initial visit with Dr. He, and no claim was filed. This was within the Kaiser system. There was no referral to occupational medicine, which is standard and customary, which we went over with Dr. Chan in his testimony, because there was no relationship to work as to her reported onset of this condition. And she next treated in the emergency department, and it was with a Dr. Elvinga on May 13th of 2021. And at the emergency department, she had also seen a registered nurse by the name of Van Camp. And she reported the exact same history that she reported to Dr. He just prior, that she had an insidious onset of these symptoms as a consequence of painting, a painting activity that she had performed outside of the workplace, outside of her workplace while on leave. And that's extremely important because not only do we have one individual taking that history in Dr. He at the initial visit, but we also have 2 other individuals the next month confirming the exact same history from claimant herself. Sticking to this timeline because, again, it is important here. She goes back to see Dr. He a week later on May 20th of 2021. Still no relationship whatsoever to an alleged progressive worsening of back pain over the course of her employment. Instead, she references this time to Dr. He that she had slept for the past month and a half, basically had been bedridden, mourning for the unfortunate suicide of her father. And she questioned whether that was what precipitated these types of symptoms, and offered that as a theory at that time. She then saw a Dr. Sangan, and this was on June 8 of 2021. And again, this doctor, this is the 4th individual who's recorded a history directly from the claimant closest in time to the onset of her symptoms. And claimant said that she had 2 months of left low back pain and pain radiating to her foot. And it noted, quote, the patient states her father passed away, slept on a couch, and didn't know if that is what had caused the onset of her symptoms and problems. So again, we're not talking about a progressively worsening condition. We're talking about an individual who has an acute disc herniation with symptoms down into the leg that is now becoming symptomatic to the point where she has to seek out treatment, and it's impacting her ability to carry on activities of daily living. We then jump ahead and we have yet again another provider, a physical therapist, on November 16 of 2021. And this was recorded history of an insidious onset lying in bed grieving for her father. So again, while out on leave, performing activities that were not consistent with her employment because she wasn't working at the time. So we have numerous individuals, all different individuals, confirming the same initial history of an onset outside of the workplace that contradicted her later testimony before the board. And that's an important piece of information and important to this timeline. With respect to the claim being filed, we don't have the claim being filed until February 14 of 2022. And again, that was with the assistance of Dr. Chan When she did have the face-to-face visit finally with Dr. Chan in September of 2021, it was the claimant now who, under financial distress, out of leave, was indicating to the doctor, this is something that's work-related. I want to move forward with a claim. And Dr. Chan, as you'll see, he took her brief explanation of work duties at face value at that one visit without informing himself as to the contemporaneous medical records or other information that was available to conclude that this was an occupational disease. And counsel cited correctly to the Dennis decision, Supreme Court decision that states essentially reliable and credible medical opinion evidence is needed to establish a compensable claim. And in this instance, their evidence has to rest with Dr. Chan. And if we do walk through some of the statements that were made and concessions made by Dr. Chan, we see that the board's decision relying instead upon an orthopedic fellowship trained spine surgeon like Dr. Surson, as well as a neurologist like Dr. Zoltani, as well as a physical medicine and rehabilitation doctor like Dr. Chong, was much more where the preponderance of evidence lied here, supporting claim denial. And in turning to Dr. Chan's testimony, you'll see he provided a very cursory opinion that this constituted an occupational disease based upon the limited information he obtained at the time of that September 21 visit, which was claimant said to him she performed frequent repetitive activities of lifting between 50 to 101 pounds. And that's what he used to form the foundation or the premise for his ultimate opinion that this constituted a compensable occupational disease. And you'll see in our cross-examination, in particular, it's certified board record picking up on page 237. I had asked the doctor, first off, if it was important to have a full and complete understanding of the medical chart, the reported history as to onset of condition and other factors when addressing causation of condition. And he agreed with that. And then we went on to establish that he didn't actually do that in any aspect in this particular case. And to his credit, he conceded that. He noted, first off, at that visit where she had reported these activities and wanted to file a claim, that she had never reported this being whatsoever a progressive condition that came on over years. And that's on page 239 of the transcript and 240. So that's important because if that was the case, you think that she would be consistent with that reporting of history to Dr. Chan, as well as the numerous other providers we discussed in the timeline. But instead she wasn't, and simply offered that as a basis to have the claim allowed and testified to it here before the board, which contradicted not only information she provided to Dr. Chan, but all of the other providers that had seen her previously. The doctor goes on to answer a number of other questions that we had asked, and specifically on page 240 and 241, I had asked the doctor, well, did you ask specifically whether or not she had an onset of this condition while performing workplace duties or problems? And he said that he didn't ask whatsoever when this occurred. He just assumed, and you'll see within his testimony that he had noted on page 247, I had asked him, quote, you believe that there was an onset of these symptoms and problems in May of 2021. And then he said yes. And I went on to ask, was it also your understanding that she was continuing to work in her capacity, stacking boxes and doing other activities at the paper mill up to the point of onset for her condition? And he said yes. So in other words, I asked him that it was his belief that she was performing frequent lifting of 50 to 100 pounds throughout her shift, and ultimately had an onset of lumbar pain and problems down into the left lower extremity, warranting her going to urgent care to seek treatment. And he said, yeah, that's true. That was my understanding, that she was performing these intensive job duties frequently throughout her shift, all the way up to the point she had this problem, and that is what sent her to the urgent care. And we know from the history and the actual contemporaneous medical records that she was on leave for quite a period of time before she presented for treatment, and then offered a different causation onset as to why that had occurred that had nothing to do with her work. The doctor agreed that if he was mistaken on that assumption, which he was, we proved that this would have a detrimental impact on his opinion. And it's those concessions, Judge, when we look at an individual who concedes that he didn't look at the entire record, who concedes that if, you know, the things that I believe to be true, in fact, were not true, then that would have a detrimental impact on my opinion. That does not allow us to provide, you know, a preponderance of medical opinion evidence as contemplated by the dentist decision to allow an occupational disease claim here. I'll point out as well, there's a PAR decision, which I always like to cite to. It's a Supreme Court decision, and it basically states or holds for the proposition that medical testimony does not have sufficient probative value to support causal relationship when based on inaccurate and incomplete information. And that's exactly what we have here with respect to Dr. Chong. And he admits it. He admits it himself. And that's why, as you'll see when you review the transcripts of Dr. Zoltani, Surson, and Chong, they did have all of the records. They had the contemporaneous treatment records to establish a valid timeline. They had her discovery deposition where she went into extensive detail about her contended distinctive conditions of employment. They had a job analysis, which counsel in her briefing, as well as in argument today, has contended was inaccurate somehow. And because it was inaccurate, our expert opinion evidence should be disregarded. But you'll see, in fact, that we called a vocational counselor as well, one who's worked in this industry for, I believe, 25 years, Julie Bush. And she had testified that she's been in box plant factories. She's seen this type of work, that this job analysis was consistent with her own observation of the exact work that was done. And it was much less physical than what it is she had represented Ms. Glassett Hanson to Dr. Chan. There were not lifting of up to 101 pounds. There was not frequent 50 to 101 pounds lifting. There were assisted air devices for these pallets that essentially do the work. You're just moving it across an air-assisted line. So all of these things just simply were not inaccurate as contained within the job analysis that was reviewed by our experts and not Dr. Chan to inform his opinions. The other big piece on the job duties was testimony from claimant's supervisor, Mr. Wilcox. And what's unique about Mr. Wilcox is that he was actually hired on the same day to do the same job as Ms. Glassett Hanson was. And he worked his way up to a supervisor and ultimately became her supervisor during the last year that she was working with Westrock. And he testified he had done all those same positions, and the lifting requirements simply were not what she was representing to Dr. Chan. The 50 to 101 pounds was not accurate. And this is coming firsthand from an individual who was hired at the same time and performed the exact same jobs. And one of the other big pieces of information, which I think is important, that came from Mr. Wilcox, he had noted not only was she out on leave when there was an onset of this condition, but she actually wasn't even performing the position that she said had resulted in this particular lumbar condition. She was training for the 2 months prior to her going out on leave. So essentially, beginning in January, at the very least, up to the point she went out on leave, she was training in a new position. And you'll see that new position required her simply to operate a joystick. So she wasn't even doing any lifting. And this is coming firsthand from Mr. Wilcox, who said not only is she not doing any of this lifting to the extent that she represented when she was performing these positions that she said she had done for Westrock, before she went out on leave, she was training into a new position, and it was even lighter and only required her to operate a joystick. So there's a disconnect there. between Ms. Glassett Hanson's testimony and representations and then those who actually observed and saw her and established a valid timeline, which only the employer's experts in this particular case had an accurate understanding of, and you can see why, with that accurate understanding, the preponderance of evidence would rest with them. So those are some of the things that I just wanted you to key in on here when you review that record. In particular, Dr. He's concessions with respect to him not reviewing all of the important information and agreeing that this would have a detrimental impact. And to counter claimant's counsel, our experts they did rely upon the full and complete record here. And that's why the board judge correctly gave them more credibility, more reliability, and ultimately rendering this decision to reject this claim. You'll see as well, in particular, Dr. Surson, like I mentioned, he's a fellowship trained spine surgeon. He had testified treating roughly 1,000 patients like this who have had an insidious onset of herniations resulting in a need for surgery. And, you know, that's testimony just based upon his experience.
You'll see as well.
Based upon his experience as well as his review of medical literature, which again was not cited to by Dr. Chan, that puts him in a much more superior position to render an opinion with respect to causation. So those factors, our experts who did review more information, our experts who did actually have a complete and full understanding of the positions performed and work duties performed by Ms. Glassett Hanson, as well as those who reviewed the contemporaneous medical records to inform themselves as to the actual onset of her condition, which again took place outside of work. All of those things support the employer's position that this occupational disease claim should be denied, and we respectfully request that you affirm the board decision. Thank you.
Thank you. And counsel response, if any?
Yes, thank you, Your Honor. Just a few brief points. First, I just want to key in that there's nothing legally significant about the timing of an application for workers' compensation benefits in this case, because claimants are permitted to apply for benefits within the statutory period of 1 year, and Ms. Glassett Hanson did apply for benefits within 1 year of the onset of her occupational injury. So pointing to that is not evidence that her claim lacks merit. She was permitted to apply for benefits within that period. Second, the employer's focus on Ms. Glassett Hanson's father's unfortunate suicide and her bathroom painting incident is a distraction to avoid occupational exposure. Those facts do not explain a disabling low back condition that persisted for nearly a year, required ongoing treatment, and ultimately led to surgery. A temporary muscle pull of painting baseboards with a cat scratch, I believe is what the record reflects, would resolve. Her back condition did not. And third, there's no evidence that Ms. Glassett Hanson had a prior history of back problems before her work at West Rock. She entered employment healthy. She passed West Rock's pre-employment physical and developed these symptoms only after years of working at West Rock, 5 years of physically demanding labor and covering for other people at West Rock as well. And her attending provider agreed that the work was causally related to that condition. And the attending provider does not need to be the first provider a claimant sees. Dr. Chan treated Ms. Glassett Hanson, she followed her condition, reviewed the imaging, and subsequently came to the conclusion that it was caused by her work. And the court should not, I know it's now 2026, the court should not ignore the practical reality that in 2021, medical care was still deeply impacted by the COVID pandemic. So the fact that she had virtual appointments with Dr. Chan to begin with is again another distraction, as many appointments were being conducted virtually. As a personal note, law school was still virtual at that time for me through the end of summer of 2021. We were not permitted to be in person. And one more thing, the employer cannot simply prevail by counting their witnesses. More witnesses do not mean better evidence. The court still needs to weigh the foundation and reliability of the testimony and review the CABR and consider whether the witnesses had a vested interest or firsthand knowledge of the actual work Ms. Glassett Hanson performed. Here, Mr. Schopper brought up that the supervisor testified on behalf of the employer, but that supervisor has an obvious vested interest in defending the employer's job description of the job. He's a superior officer still at West Rock. And the vocational counselor never observed Ms. Glassett Hanson performing the work, and she did not even inspect the actual box plant at issue. This is all reflected in the CABR. And that limits the weight the court should give these opinions and still does not overcome the requirement that the attending physician, Dr. Chan, is to be given special consideration. And one last point, counsel's argument about coverage case law ignores Nelson versus the Department of Labor and Industries, cited in my brief, which says remedial acts should be construed broadly and liberally in order to effectuate their purpose of benefiting workers. The worker is to be taken as she is, and Ms. Glassett Hanson's claim should have been allowed. Thank you.
Right. Mr. Schopper, normally I wouldn't have anything. I didn't hear anything really new in that. Is there anything in there specifically you wanted to comment on?
No, Judge, I don't think so. Thank you.
Okay. Well, counsel, I'm not going to give you an estimated date because I've got about 500 pages I'm going to have to read in between all of the other duties. I'm going to try and schedule a day where I can just sit down and read the whole thing. Sometimes that's challenging. I will put this on as fast a track as I can get it done and get a written decision out to you. Do you prefer that sent via email to you both? Is that the best? Okay. So my staff, one of my staff will be Kelly Holter. We'll send you an email. We'll have it attached to whatever I do come up with and file. And then I hope you both have a safe and happy 4th of July.
You as well.
Thank you, Your Honor. You too.
Thank you, everyone.